kinds of condition. Suspensive. The happening of the condition or event gives rise to the obligation or acquisition of rights. Resolutory. The happening of the condition or event extinguishes obligations or rights. Potestative. The happening or performance depends upon the will of a party. If performance depends upon the sole will of the debtor, the obligation is void. If the performance depends upon the sole will of the creditor, the obligation is valid. Casual. The happening or fulfillment depends on chance or will of a third person. Mixed. Fulfillment depends partly on chance or the will of third person and partly on the will of one party. Possible. By its very nature, it can be fulfilled, or it is not against law, public policy, or good custom. Impossible. By its nature, it cannot be realized, or it is against law, good customs, or public policy. Positive. Something is to be done, or an act shall be performed. Negative. It is required that something will not be done, or an act will be omitted. Divisible. It can be partially complied with. Indivisible. It is not susceptible of partial compliance and must always be wholly complied with. Conjunctive. There are two or more conditions that must all be complied with. Alternative. There are two or more conditions, but compliance or the happening of one is sufficient. Express. The condition is stated either orally or in writing. Implied. The condition is not stated, but is deemed attached. In a nutshell, suspensive condition means that the acquisition of rights shall depend upon the happening of an event that constitutes the condition. The birth or effectivity of the obligation can take place only if and when the condition happens or is fulfilled. It is the condition precedent, and the obligation cannot be enforced unless the condition is complied with. The non-compliance of a suspensive condition is not a breach, casual or serious, but simply an event which prevented the obligation from acquiring obligatory force. Resolutory condition, on the other hand, means the loss or extinguishment of rights already acquired depends upon the happening of the event that constitutes the condition. It is the condition subsequent, as in 2011 bar. Examples: in a contract to sell a car, the obligation to deliver and to transfer ownership of the car is subject to full payment of the price. Full payment of the price is a suspensive condition because it is a future and uncertain event that will give rise to the acquisition by the buyer of the rights as owner. Another example: if the agreement that Mr. X will pay Mr. Y the amount of $2,000 if Mr. Y will pass the 2019 bar, the agreement is subject to a condition. Passing the examination is a suspensive condition because it is a future and uncertain event that will give rise to the obligation to pay. Another example: the agreement that Mr. A will deliver and transfer his car to Mr. B immediately, and Mr. B will become the owner of the car, subject to the stipulation that if Mr. B will fail in the bar examination in a given future date, Mr. B will have to return the car to Mr. A. Failure to pass in the examination is a resolutory condition because it is a future event that will extinguish the rights of Mr. B over the car. Article 1182 on potestative conditions. A condition is potestative if the happening of the future and uncertain event that constitutes the condition is dependent upon the sole will of one party. It is up to the party to decide whether or not he will perform the designated event. Effects of suspensive potestative condition. Will of obligor. If the fulfillment of the suspensive condition that will give rise to the obligation depends upon the will of the debtor or obligor, the conditional obligation is void. Examples: 1. If Mr. A will pay when he likes to pay. 2. If Mr. A will deliver if he decides to sell his specified property. 3. Mr. A agrees to deliver a horse when he feels like it. Will of creditor. If the fulfillment of the suspensive condition depends upon the will of the creditor, the obligation is valid. Example: if Mr. A will deliver the subject property to Mr. B when Mr. B decides to make a demand from Mr. A. Not attached on birth of obligation. If the suspensive potestative condition is attached not to the birth of the obligation but on the fulfillment or performance of an obligation that is already existing, valid, and the court must fix the period to comply. 1996 bar. Examples: Mr. A is indebted to Mr. B, hence Mr. A is obligated to pay Mr. B. However, while Mr. A is obligated to pay, he can decide when he wants to pay. Effects of resolutory potestative condition. Will of obligor. If the fulfillment of a resolutory condition depends upon the will of the debtor or obligor, the obligation is valid. Example: a perfected contract of sale where Mr. B is obligated to deliver a car to Mr. A, creditor. B has the right to cancel the sale if the manufacturer failed to ship the car to Mr. B within a certain period. Will of creditor. If the fulfillment of the resolutory condition depends upon the will of the creditor, the obligation is valid. Example: a perfected contract of sale where Mr. B is obligated to deliver a car to Mr. A, creditor. Mr. A has the right to cancel the sale if the manufacturer failed to ship the car to Mr. B within a certain period. Casual conditions, Article 1182. A casual condition is one where the fulfillment is dependent on chance and or the will of the third person. This condition is valid. Examples: 1. Mr. A will deliver a sack of rice to Mr. B if there will be a typhoon in the first week of the month following the execution of the agreement. 2. Mr. B will deliver the machinery to Mr. A upon his receipt of the same machinery from Mr. C, who will ship the same from Japan. Mixed conditions. Mixed conditions are present if the same depends partly upon the will of the parties and partly upon chance or the will of a third person. Example: 1. Mr. A will pay the balance of the price of the house to the seller, Mr. B, if Mr. C, the present possessor, will vacate, and Mr. B will see to it that Mr. C will vacate the same. Number 2. Mr. A promises to give his grandson a car if the latter passes the bar examinations. In a mixed obligation, when the condition was not fulfilled but the obligor did all in his power to comply with the obligation, the condition should be deemed satisfied. Positive and negative conditions, Articles 1184 and 1185. Positive conditions. An event is supposed to transpire or something must happen or must be done. Examples: Mr. A is obliged to pay Mr. B if Mr. B will become a lawyer in 2014. If 2014 expires without B becoming a lawyer, then the obligation to pay will not arise. 2. Mr. A delivered a house to Mr. B with the condition that Mr. B will become a certified public accountant in 2015. If 2015 expires without B becoming a certified public accountant, Mr. B has to return the house to Mr. A. 3. Mr. X agrees to deliver a motorcycle to Mr. Y on the condition that Mr. Y will win in the New York Marathon in 2015. The obligation to deliver is extinguished if Mr. Y will tragically lose his legs before 2015 and disabled persons are disqualified to join the marathon. it is now indubitable that the event, winning the New York Marathon, will not take place. Negative condition: an event is not supposed to happen or something must not be done. Examples: Mr. A agreed to deliver the house to Mr. B provided that Mr. B will not marry Miss C and be the latter's first and only husband up to 2014. If 2014 expires without Mr. B marrying Miss C, the obligation to deliver arises. In the previous problem, the same conclusion will result if Mr. C will marry Mr. D before 2006, because it becomes indubitable that Mr. B will not become the first husband of Miss C, even if Mr. D will die in the meantime. Impossible conditions, Article 1183. In impossible conditions, the impossibility of the condition may be juridical or physical. The impossibility is juridical when a legal and permanent obstacle obstructs its realization, while it is physical if the realization of the event is incompatible or contrary to nature. Examples: 1. Mr. A will deliver a car to Miss B if Miss B will commit a crime. The condition is contrary to law and public policy. 2. Mr. A will deliver a car to Mr. B if Mr. B will dance on the sun. The condition is a physical impossibility. Effects of positive impossible crime. The impossible positive condition makes the obligation void. 2. If the impossible positive condition's effect is only partial and the obligation is divisible, the portion not affected shall be valid. Exception: in donation, only the impossible condition is void, not the donation itself. Effects of negative impossible condition. The impossible negative condition shall be disregarded. The obligation is valid and the impossible negative condition is deemed not imposed. Examples: 1. Mr. A obliged himself to give Mr. B a car if Mr. B will not dance on the sun. 2. The delivery of the property makes the debtor the owner, but he cannot dance on the sun, otherwise the transfer of the property is annulled and he has to return the property. Constructive fulfillment of suspensive condition, Article 1186. If the obligor voluntarily prevents the fulfillment of the suspensive condition, the condition is deemed fulfilled. The requisites for constructive fulfillment to be present are as follows: 1. The intent of the obligor to prevent the fulfillment of the condition, and 2. The actual prevention of fulfillment. Mere intention of the debtor to prevent the happening of the condition or to place an effective obstacle to its compliance without actually preventing the fulfillment is insufficient. Example: Mr. X will deliver a car to Mr. Y if Mr. Y passes the examination that he should take on a specified date. However, Mr. X paid a group of persons to detain Mr. Y so that Mr. Y cannot take the examination on the specified date. There is a ruling of the Supreme Court to the effect that Article 1186 and constructive fulfillment of obligations applies only to a suspensive condition and not to a resolutory condition. Rights before fulfillment of suspensive and resolutory conditions. Suspensive condition: preservation. The creditor may perform or file an action for the preservation of his right. The right given to the creditor is to make sure that the obligation will not be rendered illusory. Examples: 1. Judicial action to stop the conveyance of the property that is the object of the obligation. Extrajudicial action, like filing a notice of adverse claim with the Register of Deeds, register a notice of his claim. 2. The debtor cannot be required to pay, and if he will pay, he may recover what he paid by mistake. For instance, if the determinate thing which is the object of the obligation will not be preserved, or will become out of reach because it will be transferred to a third person, then the creditor cannot expect that the thing will be delivered to him. Resolutory condition. The creditor can compel compliance with the obligation because the obligation is already demandable, subject to the happening of the condition. Rights upon fulfillment of suspensive and resolutory conditions. Suspensive condition as an obligations to give. 1. Retroactivity, Article 1187. The effect shall retroact back to the time when the obligation was constituted. Example, Mr. X is supposed to deliver a lot to Mr. Y. Since the right of the creditor, Mr. Y shall retroact. Mr. X cannot transfer the lot to anybody, even before the fulfillment of the obligation. 2. As to fruits, Article 1187. Reciprocal obligations. Each party will retain the fruits that they received and shall be deemed mutually compensated. Example, Mr. X is supposed to deliver a house to Mr. Y, and in return, Mr. Y is supposed to deliver a rice field to Mr. X, subject to a suspensive condition. Mr. Y is not required to deliver all his harvests before the fulfillment of the suspensive condition, and Mr. X is not supposed to pay the rentals he may have received before the fulfillment of the suspensive condition. Another, unilateral, the debtor shall appropriate the fruits and interests received unless the contrary intention appears. As to obligations to do or not to do, the courts shall determine the retroactive effects. Resolutory condition. There shall be mutual restitution. The parties shall return to each other what they received. Rights upon failure to fulfill suspensive or resolutory condition. Under suspensive condition, the supposed obligation does not obtain obligatory force. The obligation will not arise. A. The obligee may either A. refuse to proceed with the agreement, or B. waive the fulfillment of the condition. B. Where a party's conduct shows that he did not only disregard the condition but also placed the other party in a position that his compliance is no longer necessary, the former is deemed to have effectively waived compliance with the condition. Under resolutory condition, the obligation will not be extinguished or will remain in force. Rules on loss, deterioration, and improvement before fulfillment of suspensive condition, Article 1189. For the rules to apply, the object of the contract involved must be specific or determinate. Before the fulfillment of the suspensive condition, the thing may be lost, may deteriorate, or there may be improvement on the determinate or specific thing. Note, it cannot be generic because any object belonging to the class can be delivered even if what the debtor intended to deliver is lost. 1. Loss. It is understood that the thing is lost when it perishes or goes out of commerce or disappears in such a way that its existence is unknown or it cannot be recovered. 2. Deterioration. When the thing's value is reduced or when it is partially impaired. 3. Improvement. When something is added to the thing that increases its value or when the utility of the thing is increased. A loss and deterioration of the thing may either be attributable to the debtor's fault or negligence in whole or in part, or the same can happen without the fault or negligence of the debtor. Similarly, improvement may be due to the debtor in whole or in part, or it may be due to fortuitous event. Rules on loss. A. Loss without debtor's fault. Obligation is extinguished. Example, the thing is lost solely due to typhoon. Loss. B. Loss where debtor is at fault. Debtor is liable for damages. Example, the debtor was negligent in storing the machine that he is supposed to deliver. Hence, the same was destroyed. Rules on deterioration without debtor's fault. Creditor shall bear the deterioration. Example, If the only cause of the deterioration is typhoon, the thing shall be delivered to the creditor even if deteriorated. The debtor will not be liable for damages. Due to debtor's fault, creditor can choose one of the following: 1. Rescission plus damages, or 2. Specific performance plus damages. Rules on improvement. By nature or through time, creditor will get the improvement. Example, the creditor will get the alluvion of on the property. B. Due to debtor's expense, debtor shall be entitled to reimbursement for necessary expenses. Example, preservation of the thing, but he is not entitled to expenses for the improvement itself or expenses for ornaments. Rules on loss, deterioration, or improvement upon fulfillment of resolutory condition, Article 1190. The right or obligation is extinguished upon the happening of the resolutory condition. Hence, the law aims to restore the parties as far as practicable to their positions when the obligation was constituted. Consequently, the parties are supposed to return what they received. Rules on loss. Without the fault of the person who will return, obligation to return is extinguished. Example, the resolutory condition occurred, but the thing to be returned was lost solely due to the typhoon. The person who will return is at fault. He is liable for damages. Example, the resolutory condition happened, but in the meantime, the person who was supposed to return a machine was negligent in driving the truck where the machine was supposed to be transported, thereby destroying the machine. Rules on deterioration. Without the fault of the person who will return, the person who is supposed to receive shall bear the deterioration. Example, if the only cause of the deterioration is typhoon, the thing shall be returned to the other party, even if deteriorated. The person who will return will not be liable for damages. How about due to the fault of person who will return? The person entitled to receive can choose one of the following: rescission plus damages, or disregard the resolutory condition and proceed with the contract plus damages. What is the rule on improvement? A. By nature or through time, the person to whom the thing will be returned will get the improvement. To the expense of the person who will return, the person who will return shall be entitled to reimbursement for necessary expenses. Example, preservation of the thing, but he is not entitled to expenses for the improvement itself or expenses for ornaments. What is reciprocal obligations? In reciprocal obligations, the obligation or promise of each party is the consideration for that of the other. The performance of one obligation is conditioned on the fulfillment of the other obligation. Examples: 1. A contract of sale is a reciprocal transaction because the promise of each party is the cause or consideration for the obligation or promise by the other. 2. The buyer of a house and lot is not obliged to pay if the seller has not yet completed the house within the period agreed upon. What are the remedies in case of breach? In case of breach, the injured party can choose one of the following: 1. Specific performance plus damages, or 2. Resolution or rescission with damages. Only one can be chosen because these remedies are alternative remedies. However, Article 1191 provides that rescission can still be availed of even if the injured party has already chosen specific performance, if specific performance becomes impossible. These remedies are available to the injured party even if there is no provision in the contract that gives him such right. Article 1191 expressly provides that the power to rescind is implied so long as the obligation is reciprocal in nature. Under resolution or rescission under Article 1191 means unmaking of a contract for a legally sufficient reason. It abrogates the contract from its inception and restores the parties to their original positions as if no contract has been made. What are specific rules in rescission of reciprocal obligation? It is predicated on a breach of faith by the other party who violates the reciprocity between them. Rescission is allowed if one party is ready and willing to comply, but the other party cannot or will not perform his corresponding obligation. The breaches with respect to obligations that are already extant or existing and not failure to render the obligation binding. Thus, if the birth of the obligation is subject to a suspensive condition, the non-fulfillment of the obligation does not give the party a right to rescind under Article 1191. There is no need to rescind an obligation because there is still no obligation in the first place. For example, in a contract to sell, where the full payment of the price is the suspensive condition for the transfer of ownership, non-fulfillment of the condition, that is non-payment, will prevent the birth of the obligation to transfer ownership. There is no need to rescind because there was never an obligation to transfer ownership. Another is if the person who will rescind is the injured party, that is, the person who is ready and willing to comply. Next, mutual restitution is required if there is rescission. Rescission can be carried out only when one who demands it can return whatever he may be obliged to restore. Rescission creates the obligation to return the things which were the objects of the contract together with their fruits and interest. And finally, rescission will not be permitted for a slight or casual breach, but only such substantial and fundamental breaches would defeat the very object of the parties in making the agreement. Examples of casual breach. In Song Pho versus Hawaiian Philippines Company, it was ruled that a delay in the payment for a small quantity of molasses for some 20 days is not such a violation of an essential condition of the contract that warrants rescission due to non-performance. In Philippine Amusement Enterprises versus Natividad, the Supreme Court declined rescission for the occasional failure of the phonograph to operate, not frequent enough to render it unsuitable and unserviceable. In La Forteza versus Machuca, the court ruled that the delay of 1 month in payment was a mere casual breach that would not entitle the respondents to rescind the contract. In Ang versus Court of Appeals, the court held that the failure to remove and clear the subject property occupants and obstructions and deliver all the pertinent papers to the vendees for the registration and issuance of a certificate of title in their name were not essential conditions but merely incidental undertakings which will not permit rescission. In Power Commercial and Industrial versus Court of Appeals, the Supreme Court considered the failure of the vendor to eject the occupants of a lot sold as a usual warranty against eviction, and not a condition that was not met, and thus rescission was not allowed. In Del Castillo versus Nagiat, the High Court ruled that the failure to pay in full the purchase price stipulated in the deed of sale was not ipso facto grant the seller the right to rescind the agreement. When a party has already been compensated for the other party's defaults, such defaults cannot be considered as a substantial breach that justifies the rescission of the contract. The court may choose not to declare that the contract is rescinded if there is a just and valid ground to fix a period instead. Article 1191 contemplates judicial rescission. In other words, a case should be filed in court. The parties can also stipulate in the contract that there can be rescission even without court action. There is nothing in Article 1191 which prohibits the parties from entering into an agreement that a violation of the terms of the contract would cause its cancellation even without court intervention. Even if there is a provision in the contract providing for cancellation even without judicial intervention, the cancellation can still be reviewed by the court. Moreover, the injured party cannot take the law in his own hands and forcibly take what he delivered. Rescission, more appropriately called resolution under Article 1191, is different from rescission of a rescissible contract under Article 1383. The remedy under Article 1191 is also called rescission, but it is not the same as rescission of a defective contract for lien under Article 1381. How about a mutual breach? In case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. This rule is fair to both parties because the second infractor also derived or thought he would derive some advantage by his own act or neglect. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished, and each shall bear his own damages. The second rule is likewise just because it is presumed that both at about the same time try to reap some benefits. This rule should also be applied in case the obligation is pure and both parties are not willing to comply with their respective obligations. Hey, and before I continue with obligations with a period and kinds of periods, let's take a quick break and do me some favor and hit that subscribe button and let this ad placed here or wherever play. Thanks. Obligations with a period. An obligation is with a period if an interval of time is provided for which either suspends the demandability of an obligation or will terminate existing obligation. A period can either be a fixed date or a day which must necessarily come, although it may not be known when. Period distinguished from condition. Period involves a future and a certain time or event. Condition involves a future and uncertain event. Period. Suspensive period affects only the demandability of the obligation. Suspensive condition affects the birth of the obligation and not merely its demandability. Generally, there is no retroactive effect under period, while there is retroactive effect in a condition. Under the period, the obligation is still existing if the period depends upon the will of the obligor, while under condition, the obligation is void if the condition depends upon the will of the obligor. What does the phrase, "when the means of the debtor permits," mean? Under Article 1180, there is a period if the debtor binds himself to pay when his means permit him to do so. The law does not consider the event as something that is dependent upon the will of the debtor, nor does it treat it as a future and uncertain event. Consequently, the creditor may ask the court to fix the actual date of performance pursuant to Article 1197. Kinds of period. Suspensive, XD. Nature. Suspends the demandability of obligation up to the period agreed upon. Resolutory, in diem. Obligation is immediately effective and demandable but will be extinguished when the period arrives. Legal, fixed by law itself. Conventional, agreed upon by the parties. Judicial, fixed by the court. Definite, exact date is specified. Example, payable on January 10, 2025. Indefinite, the date is not fixed. When an event which is certain to happen is specified, although the exact date is unknown, it falls under indefinite. Example, death of a specified person. Illustration, M and N were very good friends. N borrowed 10,000 from M. Because of their close relationship, the promissory note executed by N provided that he would pay the loan whenever his means permit. Subsequently, M and N quarreled. M now asks you to collect the loan because he is in dire need of money. What legal action, if any, would you take in behalf of M? M should file an action for the fixing of the term of the lease. Article 1180 in relation to Article 1197 of the New Civil Code provides that when the debtor binds himself to pay when his means permit him to do so, the obligation shall be deemed to be one with a period, and the creditor may ask the court to fix the period. In the present case, there is no fixed period for the payment of the loan, hence N cannot be considered in default. It is only after N failed to pay despite demand, within the period fixed by the court, that M can file an action against N for specific performance. How about suspensive and resolutory period? Obligations with suspensive period. Obligations for whose fulfillment a day certain has been fixed shall be demandable only when that day comes. Example: 1. Mr. X shall deliver the horse to Mr. Y on January 15, 2020. Mr. Y cannot demand the delivery of the horse before such date. 2. Mr. A will deliver the house and lot to Mr. B when Mr. C dies. The death of Mr. C is certain to happen, although the date when it will happen is uncertain. Obligations with resolutory period. These obligations take effect at once, but terminate upon arrival of the day certain. Example: Mr. X will deliver a sack of rice to Mr. Y for a year, or up to January 10, 2020. The obligation to deliver rice takes effect at once, but it will stop by January 10, 2020. How about loss, deterioration, or improvement in obligations with suspensive period? Under Article 1194. Rules on loss before arrival of period. Without debtor's fault, obligation is extinguished. Example: Mr. X is supposed to deliver a car on January 5, 2014, but the car was lost solely due to typhoon. The obligation to deliver the car is extinguished. But when debtor is at fault, debtor is liable for damages. Rules on deterioration before the arrival of period. Without debtor's fault, creditor shall bear the deterioration. Example: the debtor, Mr. A, was supposed to deliver a motorcycle to Mr. B on January 5, 2014. However, prior to January 5, 2014, the motorcycle deteriorated, and the only cause of deterioration is typhoon. The thing shall be delivered to the creditor even if deteriorated, and the debtor will not be liable for damages. But when due to debtor's fault, creditor can choose one of the following: 1. Rescission plus damages, or 2. Specific performance plus damages. What is the rule on improvement before the arrival of the period? When it's by nature or through time, creditor will get the improvement. Example: before the delivery of the land on the date agreed upon, January 5, 2015, the land that is supposed to be delivered was increased in the meantime when sediments were deposited on the banks of the river little by little. The creditor will get this additional portion. But when due to debtor's expense, debtor shall be entitled to reimbursement for necessary expenses. Example: preservation of the thing, but he is not entitled to expenses for the improvement itself or expenses for ornaments. What happens when it's delivery by mistake? Article 1195. Anything paid or delivered before the arrival of the suspensive period, the obligor being unaware of the period or believing that the obligation has become due and demandable, may be recovered with the fruits and interests. Thus, the provision is applicable only if 1. The obligation involved is an obligation to give. 2. The period is for the benefit of the creditor and debtor. 3. The obligor delivered before the period. And 4. The obligor is not aware of the period, or he believes that the obligation has become due and demandable. Example: Mr. A agreed to deliver a pig on March 5, 2014. He delivered the pig on January 5, 2014. thinking that the date of delivery is January 5, 2014. Mr. A can recover the pig from Mr. B with foots and interest. When it is not applicable, the provision is not applicable in the following instances. 1. Obligations to do and not to do. 2. In reciprocal obligations and both parties prematurely perform their respective obligation. 3. When the period is for the benefit of the creditor alone. 4. When the debtor voluntarily and knowingly delivered the thing knowing that the obligation is not due, in which case this is just prepayment. So what is the effect of bad faith of creditor? According to Tolentino, the rule on solutia in debiti should be applied. If in bad faith, the creditor must pay the foots or interest. If in good faith, he will pay only insofar as he was benefited. What is the presumption for whose benefit is the period? The period fixed by the parties is disputably presumed to be for the benefit of both the creditor and the debtor. What is the effect of presumption? The creditor cannot demand payment or performance before the period unless the debtor consents, and the debtor cannot prematurely pay or comply unless the creditor consents. What is the rule if the period is in favor of the creditor? The creditor can demand performance of the obligation even before the stipulated period, or he can wait for the fixed period. The debtor cannot insist on complying with his obligation before the period. Examples: Mr. X delivered his dog to Mr. Y for safekeeping for a period of 1 month. Mr. Y may not return the dog before the expiration of the period. Mr. X can get the dog back even before the expiration of the period. The nature of the obligation indicates that the period is for the benefit of the creditor, Mr. X. Another, Mr. X leased his house to Mr. Y for a period of 1 year. It was agreed that Mr. Y cannot pre-terminate the lease. In this case, tenant Mr. Y cannot terminate the contract of lease before the lapse of the 1 year period. Even if he will abandon the house, he has to pay the rentals corresponding to the 1 year period agreed upon. What is the rule if the period is in favor of the debtor? The debtor can insist on paying or complying even before the lapse of the period that is fixed in the agreement. Example: the debtor can pay on or before December 10, 2015. In this case, the period is for the debtor's benefit because the debtor can pay on December 10, 2015 or even before such date. 2. The debtor can comply within 1 year. Is the court authorized to fix the period in all cases? No. Fixing of the period, Article 1197. The court may be asked to fix a period in the following cases. 1. Period is intended. It is required that these two must concur. 1. The obligation does not fix a period, and 2. A period is intended, as can be inferred from the nature of the obligation and the circumstances. No action for specific performance can be filed unless the period is fixed. Example: the court may fix the period if the obligation is to put artesian well with tank in a lot within a reasonable time. What happens if period depends upon the will of debtor? The court may fix a period if the duration of the period depends upon the will of the debtor. Example: when the debtor agreed to pay little by little. 2. When the debtor agreed to comply as soon as possible. 3. When the debtor agreed to pay in partial payments. And 4th, when the debtor will pay as soon as he has the money. And when the debtor binds himself to pay when his means permits him to do so. In this case, the court may fix the period. What happens when the debtor loses the benefit of a period? Generally, the debtor cannot be compelled to pay before the expiration of the stipulated period. However, in the situations enumerated in Article 1198, the debtor loses every right to make use of the period. In other words, the creditor can make the debtor comply with the obligation even before the fixed maturity date or the expiration of the period. These are cases when the debtor loses the benefit of a period. 1. When after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security for the debt. 2. When he does not furnish to the creditor the guarantees or securities which he has promised. 3. When by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear, unless he immediately gives new ones equally satisfactory. 4th, when the debtor violates any undertaking in consideration of which the creditor agreed to the period. And 5th, when the debtor attempts to abscond. What does an acceleration clause do? In addition to the grounds mentioned in Article 1198, the debtor may also lose the benefit of a period if there is an acceleration clause.